Hello, my true crime lovelies. How are you? I hope you are well. I hope you are as lovely in life as you are in my mind. I also hope you can hear me because I just realized my mic was low. I there's a lot going on with Sarah. So one, Josh left her. So if you haven't seen that video, check that video out. This video is about Judge Jackson in the trial of the family court business that's going on. And I will say Miss Jackson is a woman with clear boundaries. We're going to get into it in this video. And then there will be a third, which has 33 pages from Sarah. And it's not a parenting plan. It's not a financial plan. She's calling it a pretrial plan, but it's more like a rant. I mean, as you can imagine, in 33 pages. So I don't know if Sarah's the gift that keeps on giving or the curse that keeps on cursing, but we're going to have it all today. This one is going to be about Judge Jackson, like I said, and I think she is leaving no room for ambiguity, clear instructions, which I appreciate, but also just clear boundaries. And we know our friend Sarah is not a friend of boundaries. She has 9 third-party representatives. None of them are named boundary or rules or compliance. So we'll get into that. Let me run the intro and we'll talk about it. If I can find the intro, there we go. We'll talk about it on the other side. How you doing? Let me know down in the comments. I'm curious. All right. Also, for my docket watchers, there are 3 things that Judge Jackson filed yesterday. One of them is that Sarah is now going to be appearing telephonically, not even via Zoom. So she included a phone number for that. Previously said she would be in person, but obviously, if you want to hear her, you have to be there in person. And then the courtroom has been moved. So I am wondering if it's one of 2 things: a larger courtroom because a lot of people have been calling and wanting to attend, or a smaller courtroom because a lot of people have been calling and wanting to attend, and they want to limit the number of people in there. I am not sure. So I kind of want to call, but then I don't want to join a lot of people also calling, but we'll see. I'll let you know. I still am not sure that I can fly yet. I did send off my passport application and it is being expedited. It was received on Friday. I am not going to know. I got a note yesterday that it's being reviewed. So we'll see. I could not get my real ID. It's such a long story, but it's all my fault because I wasn't paying attention. That's just all there is to it. So I'm trapped on the island. All right, let's get into this. Order setting trial. So this cause is ready for final disposition. We are ready to get it over with, ma'am and sir. Accordingly, it is ordered as follows. Parties have affirmed this case is prepared for immediate trial. No additional hearing time shall be scheduled pending the final trial. She was like, I don't have time for y'all. We're going to get this one and done. Pay attention. If there are motions outstanding that are not included specifically in this order, as in this page, these pages that we're going to read together, the parties may, at least 10 days prior, file a cross notice for the same day/time as the trial. All other outstanding motions shall be deemed waived and denied. So this is important because Sarah has an open motion, the motion for contempt. So she is being told, pay attention, flying monkeys, that she needs to file a cross notice at least 10 days prior to August 25th so that it can be heard on the same day, same time as the trial, right? It will all be heard together. If she does not file that cross notice motion, that motion will be deemed waived and denied, so she can stop talking about it because she brings it up in her 33-page rant. Okay, number 3, parties have affirmed that all discovery they require for trial has been received. No additional discovery requests or motions to compel shall be entertained without extraordinary circumstances. And no, being in prison for life is not an extraordinary circumstance because you've known since December 2nd that was your fate. All exhibits must be marked prior to the start of the trial, which will begin exactly at the time listed at the end of this order. It's 1 p.m., spoiler alert. All witness lists and exhibits for trial have been exchanged or will be exchanged by August 15th, right? So we're not seeing that. It's not being entered on the docket, but they're doing it behind the scenes. I believe one of you guys said the text messages would not be entered. I didn't get that firsthand from the court or from obviously Brian or his attorney, but that is the rumor that's swirling around. Any changes to the joint pretrial memorandum or joint equitable distribution spreadsheet or parenting plan should be provided to the court no less than 3 business days prior to trial. Again, Sarah has not submitted a parenting plan. She's not submitted her official financial affidavit, the one that was meant to be typed. So I'm not sure how the judge is going to handle that, but she has until 3 days prior, 3 business days. So their trial date is on a Monday. So I think she would need to get it in Tuesday, Wednesday of the week before. The joint EDS should be in Excel. They don't have a joint anything. And the joint parenting plan should be in Word. So Brian has submitted his. It's a PDF on the court website, but presumably they'll figure out the Word part to the court. Okay, the parties shall inform the court, because I think they scan everything, so it could already be a Word document is what I'm meaning. The parties shall inform the court of any stipulated evidence that they wish the court to review prior to trial, deposition transcripts, case laws, reports of experts, etc. So before the trial, they need to let them know, and stipulated evidence, just so like to save time, if they agree that they will stipulate that the son will visit once a month or whatever it is. Like, I'm not saying that that's what they've agreed to, but things that they don't need the judge to decide. Basically, they're stipulating like, we agree on both of these and we're fine to put that on the record so it can be incorporated into whatever the order is. 7, the court shall begin the trial with any questions that it may have after a full review of the pleadings and prior orders, right? So they're going to send in all their documentation, all the case law that they want her to look up and everything else ahead of time. Deposition, whatever they want her to look at, they're going to send it ahead of time. And she's going to start the trial with any questions after having reviewed all of that, right? Looking for clarification or just confirming her understanding of it. So that's how they're going to start. Typically, an opening statement will not be necessary at the close of evidence and any remaining questions by the court. So they're going to both close out their case in chief. She's going to further ask questions if she has any, looking again for clarification or confirmation. And then a limited closing argument will be permitted upon request. So if they want to summarize it, it's not granted, they're going to need to request it. Hopefully, Brian's attorney will do a limited closing argument just to sum it all up. I think it's purposeful, intentional when she says limited closing argument. Please hold. Okay, sorry, my alarms are going off. So yeah, I think it's purposeful when she says limited. She may give them a specific time limit, and we know Sarah needs that, right? Otherwise, she could just go on and on and on. We all saw that sentencing statement. She had a written letter. She had an oral vomit. So I think the judge is being very intentional with her language here. And then all caps 8, there is no need to prepare proposed orders unless specifically requested. The court shall prepare orders and final judgments. If you have not received your order within 14 days or your final judgment, please email the judicial assistant. So here it's going to courtroom 7A. I had to redact the actual street address because YouTube doesn't allow that. It will get my video taken down for bullying. And so, but the trial is set for August 25th, 1 p.m., courtroom 7A. And if you are in need of an interpreter, blah, blah, blah. And then it goes out to all the parties. Brian via his counsel, Josh and Nancy, and then sent it to Sarah. Obviously, she does not have this yet, so I know her flying monkeys will tell her that we're all talking about her on the internet because she is the gift that keeps on giving. So what do you guys think, right? I think the judge was very concise, very clear. And I think it makes it easier that they don't have to prepare orders because Sarah's not going to be able to prepare one. And then it just saves Josh time and Brian money by not preparing orders ahead of time. Because we've seen it in the past when when lawyers have gone in and said, this is what I want. And then they include the order of what they want. So if the judge agrees to it, they just have to sign it. And she's like, no, I got you. So very interesting. I'm going to wrap this up so I can at least start on the 33 pages. I'm going to have to split it between the morning and the afternoon, so you won't see it till the evening. Just in case you're watching this, look out tonight for the 33-page rant because it's going to take me a while to get through it. I fell asleep reading it last night and I didn't get through it all myself. Okay, I've got pancakes coming for you. Yes, chocolate chip pancakes. Do you want to come and say goodbye with me?
Bye.
Bye. And then what else? Toodles.
Yeah.
Talk to you guys later.